the who cares question. Okay, so let's say you made a mistake and you included all the evidence in Form 8 or Form 10, and you did not file Form 14, right, or whatever. Like you didn't break it up and put the different forms in. You just put everything into Form 8. Like Eve just put everything into Form 8. Does that matter?
What lawyers quite often describe, and some lawyers are guilty of this. But yes, self-represented people tend to do it more often, is because they don't understand that in your initial pleading, when you're telling the court what you're asking for, you plead the law and you plead the material facts.
Right.
You don't plead evidence.
What does that mean?
What we call it is vomiting out the information, trying to get everything all into one document all at once. It's bad form. It's done.
Oh,
a judge will look at it. Like, again, so the whole thing about if you're saying, for example, if the material fact you're claiming is that you are married, you don't need to attach to your pleading a copy of the marriage certificate, because the marriage certificate is evidence. You will have to file it eventually to prove the fact that you were married, but it's a document that tends to prove a fact. The material fact you're pleading is we are married.
We are married, yes.
The marriage certificate is evidence.
Right.
You're not supposed to plead evidence. So you don't attach your marriage certificate to your pleadings. You attach the marriage certificate and refer to it in a sworn affidavit where you're saying, okay, here in my pleadings, I set out the material facts. I've stated those facts. That is what the law tells me. These are the facts that I need in order to get what I'm asking for.
Yeah.
All the stuff that goes to support those material facts are evidence. And you don't do those in your original pleading. You shouldn't. But as I said, there's a lot of self-represented evidence in their initial pleadings. And there are some lawyers that do it as well. But you'll quite often hear the comment where a judge says, well, you're pleading evidence.
Yeah, but when the judge
saying, well, okay, we separated because he assaulted me, and here is a copy of the police charges showing that he assaulted me.
Yeah.
That doesn't go in the pleadings. The material fact is he assaulted me on this date.
Would your case get thrown out because you did that? Like, would you be given a fine, or are you gonna be?
Okay, the judge will probably call on you for having shown bad form, that you've done stuff in there that you weren't supposed to do.
Right.
Most likely you're just going to get a naughty, you shouldn't have done that. You really have to start figuring out the rules, and you're bound by the rules.
Right.
The most the court would probably do is a judge might say, you know what? You're going to have to file an amended application or an amended answer. And take out the evidence that you pleaded. We'll deal with that another day. What you need to plead is the law and the material facts. Because again, what happens with the material facts, if you just say, we were married, we separated on this date, we have no children, we have no property to divide. If the other side doesn't dispute those material facts, you don't need to have any other evidence, because the side saying, yeah, I agree. You don't have to prove anything by introducing the evidence. You don't have to do a copy of the deed to the house. You don't have to do the marriage certificate. Now, the court will want to see the marriage certificate anyway, because they have to officially have that evidence to confirm the marriage was valid.
Right.
But you don't get into a fight or an argument about the evidence about whether the marriage certificate is genuine or not, unless the other side says she faked up the marriage certificate or she altered the marriage certificate. It's wrong. But so yes, it is just something you have to be very cautious about. Always just keep in mind as you read the legislation, and the legislation will tell you what are the preconditions that need to be met. What are the facts that have to exist for the court to give you what you're asking for?
Right.
Those are the facts that you set out. You don't do anything that proves that those facts are true. You just you say these are the facts. And you don't have to produce evidence unless the other side disputes those facts.